If you have been feeling the economy under the Biden administration, then you must watch this.
Welcome to the Inspired.
Yo, what is up, fam? It is January 4th, 2023, and I got some very exciting news. Today is the 4th, so 2 days from now on January 6th, the Brunson case is going to be hitting the Supreme Court, which they will have conference over. So to catch you up, in episode 2, I told you guys that I was going to mention the Brunson case and get you up to date on what's going on with that. This case, if you have been feeling the economy under the Biden administration, then you must watch this. There's a lot of exciting things going on in 2023, and I'm so glad that it's happening in the beginning of the year. But if you check this video out, basically what the Brunson case is a case that went up to the Supreme Court, and effectively when this is once this case is passed and adjudicated upon, what will happen is this case, well, actually just continue watching. I put together a video for you guys to watch that will basically explain the whole thing. Hope you guys are having a great time. Most of all, be inspired, my friends.
Boom, folks. I'm here with Lloyd Brunson and Juan O'Savin. This is going to be a special update on the SCOTUS case, if there is an update, but we're going to talk about it. What's at stake here, what's going on. I brought Juan on at the last second. Thank you for taking the call, Juanito.
Hey, well, I lost my phone. I just found it like an hour ago. So kind of fun. You know how last year when you can't find your phone, I let it go dead, and then it kicked it under a freaking table, and I didn't see where it went. It's like, oh my gosh, finally found it.
Well, I listen, man. I'm very interested to see where we're at, what the status is. I don't know if nothing's changed or what's going on. Lloyd, do you want to give my audience that maybe hasn't heard of this thus far a kind of like a brief overview of what's going on?
Sure. I have two brothers, and I are working on the legal stuff, and we through the courts we were able to get a petition to the Supreme Court. They actually allowed us to file a petition with the court, bypassing the 10th Circuit Court of Appeals, which is unheard of. They allowed us to do that because we did it under Rule 11 of their court, which identifies it as a national emergency. So when we got it to them, they called us on the phone and said that they were accepting it as a national emergency. And this petition actually gives the Supreme Court the full power to. Now, I just want to say that this has nothing to do with the outcome of the election. This is a lawsuit that's gone up through from state court to federal court to now the U.S. Supreme Court. It has nothing to do with the outcome of the election. It has nothing to do with whether there was enough fraud or not to change the outcome of the election. It simply has to do everything with the fact that after 100 members of Congress and a mountain of evidence, they refused to investigate the claims. And so every single person, member of Congress that refused to investigate the claims were suing. And so the Supreme Court now has the power to remove them from office for treason, for an act of war against the United States, the Constitution, for failing to keep their oath of office and investigating crimes that had been reported. And so this actually gives the Supreme Court the full power under this emergency act to remove 385 members of Congress, remove a sitting president, remove a sitting vice president, and bar them from holding office the rest of their lives, and also to bar Mike Pence, he's one of the defendants, from holding office the rest of his life. So that's it in a quick nutshell.
So let me ask you this, Lloyd. Is this you kind of snuck it in under the radar, right? You kind of dropped it in there, and nobody's covering this. I've told Kash Patel. I just talked to Kash Patel yesterday or a couple of days ago. He didn't even know about this. Steve Bannon. I talked to Steve Bannon. He gave me question marks on my text. Like, what are you talking about? Nobody's covering this.
Well, it's interesting. Yeah, and Glenn Beck, I saw him at Mar-a-Lago. When I was there with Juan. Juan, did you have a chance to talk to Glenn at all? We did. We spent some time with him.
I talked with staff of Glenn's, and they're certainly aware of this. I think that a lot of the people in the media are waiting to see, what happens next. For example, right now, the Supreme Court is looking at this Title 42 stuff related to the border. That's in front of them right now. The Supreme Court's, got a full plate of things coming up, and a lot of different groups are looking to them. Are they going to step in and start unraveling this Gordian knot that we're in the midst of? But it is surprising that so many media people aren't paying attention. On the other hand, you saw the article that happened the other day with Mike Huckabee. Mike Huckabee in Arkansas, he did a beautiful article on Sunday. He acknowledged Tim Canova. Tim Canova is a professor of law, has a specialty in constitutional law in Florida, and he's a law professor. He did a beautiful article that was published over at Gateway Pundit. at some level, even our letter campaign is only 2 weeks old. So, it's not like people have really understood this, and it really didn't become significant until the day after Thanksgiving. The day after Thanksgiving, when the court, said, "Yeah, we're taking this on," and then a few days later, middle of the next week, set it on the docket for the conference. I think most of the media have been so preoccupied with the border issues like that. Look at today, by the way. You probably saw this yourself, Nino, but you had CNN and MSNBC with people on the border in El Paso. El Paso is it's out of this world, and Title 42 is being looked at by the Supreme Court right now. So, this is maybe a little further down the list yet for them, a few days out.
Well, usually the press doesn't do anything unless it makes it out of conference and moves forward, because so many don't even make it through conference.
Yeah.
The fact that the fact that the Supreme Court allowed us to bypass the 10th Circuit, and we were ready because we sent them a Rule 11, which means, and they accepted that. But then the 10th Circuit made a decision before they actually filed it, because they wanted us to include some extra stuff. So during that time of including extra stuff and we sending it to them, the 10th Circuit makes a decision. So we call the court and we say, hey, do we need to take that out? And they said, you don't need it anymore. Take it out. Make sure you put what we asked you to put in it, which was a motion to dismiss presented by the U.S. attorneys. And then they said, how soon can we get it? And we said, well, a couple of weeks. And they said, we'd like to get it sooner than that. Please get it, as soon as possible. And then we got it a week sooner, and we sent it on a Thursday. They received it on a Friday, and they docketed it on a Monday. And if you look at if you go to SupremeCourt.gov and you see it, it'll show that it was filed on the day we sent it, the 20th, and they received it on the 24th. So they've already characterized this in a super positive light. And then for them to set the conference date of January 6th was just really kind of stunning. And to us, that was
so there's a lot of signs there that you're looking at that's putting this in a positive light for you.
Right. And then there's another thing. The U.S. attorneys were removed from the case, and Elizabeth Preloader, who was the United States Solicitor General, came on the day that their opposition was due. If they were going to oppose this before it goes to the conference, they had to do it no later than November 23rd, day before Thanksgiving, and they had over a month to do it. And she comes on board, and she signs a waiver, waiving her right to oppose it. She could have asked for an extension, but she signed the defendant's right away to oppose it before conference. And so that got back on the fast track, and a few days later we saw it on the docket for January 6th for the conference. I think people need to understand that the conference is where the 9 justices get together by themselves. They don't have anyone else in. They don't have anyone representing us or anyone representing the defendants. And then they review it, and then they take a vote, and they take 9 votes. And if there are 4 out of the 9 to move this forward, then it goes forward to a full hearing. But I'd also like to say that because this is a national emergency type case, and there's statutes, they're written into law where the Supreme Court, if they deem it a national emergency, they can completely adjudicate the whole complaint. Normally, it's where they uphold a decision or reverse a decision in the lower courts from the lower court. But this, they have the full power to completely adjudicate, judge it, and execute it in every aspect, all the relief. So
January 6th is going to be the time where they decide to hear it or not.
That's what it's supposed to be, but they have the full power to completely do everything before then, where it could be completely adjudicated even before then. And maybe they met with Preloader. Maybe they met with the U.S. Solicitor General. This case is only about the oath of office. It doesn't even get into any kind of interpretation of the Constitution. And it's simply about not investigating, which you have to do to preserve our national security. If crimes are reported, especially by 100 members of Congress, and you don't investigate, they violated some rules, some laws, and not investigating. And when that happens, they've created a huge security breach. So it's only about the oath of office, the Constitution, without any interpretation of the Constitution, and national security breach. I think on both sides of the aisle, you'd want evidence investigated. There were signs of
so if they decide to hear this, if they decide to hear this case, you're going to be slammed with media. Like when they decide to hear it, I'm sure it's going to catch wildfire.
Yeah. If that's what it
dibs.
Of course, Nino. Of course.
Let me ask
and let's just say this: there's a couple of different cases actually. There's 2 other cases I'm aware of that are going to be heard on the 6th that have to do with the 2020 election and election practices. So it's surprising. This is actually a big one because it could overturn, take out of office all of these members, these 388 members. But there's other cases that are very relevant too that the court has chosen to bring to conference. So, and all of this, in my opinion, is related to Roe versus Wade. The court is taking a very conservative stance. They overturned and said that a previous court erred after 50 years of settled law. So they're kind of going back in and cleaning house. And to expect that the courts, just going to kind of be namby-pamby on this and it's not going anywhere. That may be people applying a previous way the court worked with the way this specific court is working, and not getting that there's been a fundamental shift in the way that the courts decided to take this on. And let me just add this, both for you and Lloyd, we have this letter program that we're doing. We're sending one letter to the Supreme Court, asking them to review the case and to find favorably on the part of the Brunsons, and then one to the Brunsons, so that we can keep track of how many letters the court gets, because it'd be some time before we hear anything about what the number of letters is. And so there's been people that have acted like there's nothing going to happen because of the letters. On a couple of different notes, let me just say it this way. There was 100 Congress people who came up against an overwhelming number of their fellow Congress people in the House of Representatives and the Senate. And they said, you got to investigate this. You've got to look at this election. We need to send these electors back. And they got overwritten by the majority, and they just marched on and didn't do the investigation. So the question would be, was that campaign by the legislators, knowing that they were outnumbered and it was futile, was that meaningless? No, it wasn't. It had all the relevance in the world. They put a marker in, they were counted, and now it's coming around full circle. The letters are really a variation of that. You want to be citing. You have 2 million people that showed up in January 6th, 2 years ago, and said the same thing. We want investigation. We want the electors sent back to the states and investigate what happened. And by the way, do you know what this House of Representatives and Senate did during this session, during this lame duck session? They put in rule changes on how the electors count is going to be done in the future. In other words, they're trying to clean up the mess from January 6, 2020. And I guarantee you, it's to lock it in so they can get away with this anytime they want to and bypass what was required. They were required to do an investigation. There's people saying, it's not in the Constitution to have to do an investigation efforts. No. There was information from Officer Director of National Intelligence, Mr. Radcliffe, that there was Chinese interference. He spoke publicly about it. He spoke privately with members of Congress and the president about it. They did not investigate serious allegations of Chinese interference in the election that would have overturned the election. And not investigating is what this case is all about. Refusing to even look, that's the problem. It'd be like an officer when you call in, dispatch sends them a message that there's a murder taking place. And the police officer says, well, I am kind of busy right now, and I got to walk my police dog, and we're going to, go hit the coffee shop on the way. And I don't think it's a big deal. So you've ignored a report of a crime in progress where you could have made a difference.
Juanito, let me ask you a question. You've always said there's going to be no justice there will be no justice in the justice system in order for the military to make
that's words mean things. Say it correctly. I said there's no justice at the Justice Department. A lot of people misunderstand one thing. The Justice Department is under the administrative portion of government. You have the House of Representatives and the Senate on the legislative side and the money spending. You have the president and the judiciary in this other branch of government, the administration of government. The Supreme Court is a separate branch of government, and it looks at the laws that are passed. It looks at the bills that are passed and compares them to the Constitution. And so they balance out the other two branches of government and make sure that what they do is constitutional. The Justice Department, the courts, are screwed up because you hear the word court in Supreme Court. You can't confuse that with being part of the administrative side of government. They are the referee on these other matters, even with the way these cases are done. Loy, you're an expert on this stuff. Am I saying it correctly? Do I need to be?
Yeah, pretty much. It's the executive branch, and it's interesting that the Supreme Court really has a superior power. Look at the Congress, majority of the Congress, and the executive branch, the president couldn't do anything but scream and stamp their feet when Roe versus Wade was overturned. Mm-hmm. And so we the people go to the Supreme Court through the court system. Now we went straight through federal court, state and federal court. If we had hired attorneys to do this, they would have not allowed us to do that, and we wouldn't have been able to go to the Supreme Court. They would have had us get a waiver at first, a permission from the Sergeant at Arms, and actually it would have bypassed the route that takes us to the Supreme Court. We would have been stuck in a claims court if we'd even got a waiver, which I don't think we would have. So we just ran through the federal court, showing them that we had every right in the world protected under the Constitution that they sworn to uphold, federal and state. And they did it. They did what we asked them to do. It was based on our pleadings, showing them that we have a constitutionally protected right to bring our petition for redress of grievances into federal court and not go to the claims court. So
this is like a Hail Mary that they caught. That
Yes.
Well, this is Juan. How would you explain this? A miracle pass, a Hail Mary. This is something that
Well,
I don't think any of us expected.
I think it's interesting that there's a divine aspect to this, and I think all of the Brunson brothers are in agreement on this. To any scholar, when I talked to Tim Canova about this early on, and he said, the court just doesn't listen to cases like this. It'd be very unusual. I don't know of any. And in fact, coming up through the ranks like this, people say, "Oh, nothing's going to happen," etc. Loy and I had a conversation several weeks back about the fact that when you look for a case like this where national security is involved, in 100 years, there's no case that's really comparable. So people thinking that the Supreme Court is, going to act a certain way, or whatever, based on what? What are you basing your conclusion on? The court has not heard a case like this in at least 100 years. Am I saying that right, Lloyd?
Absolutely. The current justices in their careers have never categorized a petition as a national emergency petition. This is the first. And if you check history, you'll see that there might have been two others maybe. The last one was during the 70s, the Nixon administration, brought to the Supreme Court by the U.S. government. So the fact that we're pro se and we bring a case to the Supreme Court and they categorize it as a national emergency, allowing us to file it under Rule 11, which we didn't have to do because the 10th Circuit made a decision quickly. It's never happened before, ever. So this is so that's a very positive.
So already history's been made.
Factor, yeah, exactly. And I don't think the press is. I don't think I don't think they have the knowledge. They don't have a historical. I mean, if they really dug into that and saw that, then it might be a different story about being covered. That they're so used to just
imagine also they don't want to shine light on this. They don't want to put any light on this. I mean, the mainstream media to me is just as weaponized as the FBI.
Yeah, well, they can't. I mean, if they did, this is not a partisan thing. This is about removing Republicans and Democrats. So if they started slamming it, I mean, what could they say? It's like checkmate.
Lloyd, let me just ask you a question. Wasn't the one in the 70s, wasn't that the Pentagon Papers and whether or not information could be stopped from being published regarding what was going on in Vietnam like that? Isn't that the case that the Supreme Court received?
Well, I don't know.
At that time?
I was being interviewed, and there was an attorney that actually looked it up through Pacer or something to see if there had been anything. He said there was one. The last one was having to do with the Nixon administration, and so I don't know what the other.
That was the Pentagon Papers.
Yeah,
and
okay.
The reason that doesn't necessarily apply here is because that was blocking information from being released. It was on a national security basis that the challenge was, but the Supreme Court found that there was a right to publish, and. But it's really not the same as this here. This is a case of first impression.
Yeah, exactly.
And I think anybody that thinks that, let's put it this way, if you want to include the Pentagon Papers, these types of cases have rarely, that was 50 plus years ago, these kind of cases have rarely come before the court. So acting like you can know exactly how the court's going to go on this, I think that's kind of presumptuous. And
Juanito, do you trust these justices, or do you think most of them are compromised, in your opinion?
Well, wait a second. You have to.
No, I'm being serious. A lot of people are going to be asking this.
Okay, let me ask you a question.
I don't trust them. I'm just going to say me. That's me.
Okay, this is the court that decided to overturn 50 years of settled law with Roe versus Wade. Yes, I absolutely trust this court. This court is very aggressive, really. They have decided that they're not going to be thrown off of judging according to the Constitution, according to the law. They're not going to legislate from the bench. They're going to do what the Supreme Court is supposed to do. Look at what the Constitution says and decide accordingly. They looked at Roe versus Wade and said that a previous court erred. They weren't going to let a previous court get away with the mischief where they legislated from the bench. And they overturned Roe versus Wade because a good argument was presented and they decided to take it. The court had, in the last 50 years, there were numerous cases that were brought challenging Roe versus Wade, and every time the court just never even looked at the case. There's 5,000 to 8,000 cases a year that are brought before the Supreme Court, and only a couple hundred actually get reviewed, like this case is in the process of doing right now. And so you have to kind of go, well, and then to seek it out, like Loy explained to you, they were very assertive, aggressive from the clerk of the court in kind of hand holding this case up through the ranks, and it's coming pro se. You cannot, you say, well, we don't get any justice, and it's all run by big law firms and politicians and everything else. A pro se case reaches close to the Supreme Court, and they reach out and they grab it and say, here, let's help you get it all the rest of the way in. That's a court that's really kind of operating outside of any kind of a normal situation to see to it that some opportunity for justice is about to occur. I think that you have to trust this court. And
so we have a reason we can get our hopes up. We can get our hopes up on this one, because what
I don't think it's out of place to have your hopes up. I think it's correct to have your hopes up.
So
that's part of the reason.
Hold on. When they decide to hear this case, and I was going to ask Loy this. When they decide to hear this case, Loy, they can take their sweet time on when to hear it. They can kick the can down the road, or is there a certain time period they have to hear it?
Well, at 4:00 today, I'm meeting with a former member of Congress, and he believes he can get 30 immediately members of Congress to sign an amicus brief in favor of this petition. And Juan, I think I might want to put you on a phone call when we're there if you're available, talking to him.
Yeah, I'd love to. And in fact, if it wasn't for the fact that you guys are all snowed in and all the airplanes aren't working right because of snow across the East Coast, I might even fly down and spend an hour or two with you to do that. But or up or whatever it is. But the long and short of it is you guys are screwed up with the weather. By the way, when you talk to that particular person, they got those weather machine thingies. All the money we spend in the federal government, and we can't get them to just turn the dial on the weather machine thingy gobber and warm it up a little bit here. We're gonna have this.
Yeah, exactly.
They got that sucker. Right? We're not getting our money's worth here. Let's do another petition to the court. All weather machines need to be made tropical all year long.
Exactly. Yeah. Well, so he thinks he thinks the decision to dismiss is going to be overturned, and that it's going to be remanded back to the federal court, and that would mean all 380 defendants would have to answer the complaint, and then it would go into discovery where we could ask for interrogatories and depositions and investigations. So he thinks that is a possibility. To me, I think no, it's too messy and takes too long. Too much damage is being done daily, and I think I'm going to remind him that the Supreme Court has the full power to adjudicate this and save them millions of dollars after they adjudicate it fully. Let the investigations roll after that, not right now.
Well, I agree with you, Loy. If you think about where the Supreme Court is at on this, part of the logic of trying to get this case up there is that you have numerous other cases working their way up through the lower courts, and they are aware of this. You could shortstop a lot of drama in the country by getting this resolved right now. Even the stuff where the legislature is now changing the law on the electors and the way that they're managed coming in from the states and the electoral college. That's a big deal. I think that flew under everybody's radar. I don't think it flew past the justice's radar.
Do you guys think that Congress is aware of this right now, or is this just so under the radar?
That
Are they really?
Yeah, they're aware of it.
You think they're aware?
Yeah, they're aware of it. Well, of course, you got a good portion of them served by U.S. Marshals before they capped it. They know this is out there. Believe me.
Wait, can you say that again? They got served by U.S. Marshals. Why?
Well, I can tell you that.
Okay, see, there are two lawsuits alive right now. One is at the Supreme Court with Roland, my brother's name on it. But the first one that was filed was me, so I'm the plaintiff on the first one. And when I filed that, the court ordered the U.S. Marshal Service to start issuing my summons and complaints. We couldn't hire process servers because the Senate houses and the House houses were locked down. So they actually ordered the U.S. Marshal Service to start serving my summons and complaint. That was March 31st, 2021. Now, April 1st, 2021, the federal court canceled the service, canceled my filing, and said it was a clerical error. So we had to battle with them. As a matter of fact, we took the court for violating my right for due process by doing that, which was an obvious, violation of my civil rights to, petition for redress of grievances and also due process. So we took them to the 10th Circuit Court of Appeals, which is what you call a petition for writ of mandamus. And the 10th Circuit says, oh, they're not blocking you, it's just, taking time. And so we took both courts to state court. So I was a plaintiff in the defendants for the Federal Court of Utah, the U.S. District Court of Utah, and the 10th Circuit Court of Appeals. And then we battled it there for a while. It's kind of a long story. I won't get into that. But we didn't win, but we did, because after we battled them out, they changed their position. The federal court changed their position and not only allowed me to refile my case, but they filed it for me. And then they also ordered the court clerk to issue the 388 summonses. So that's still alive. That has not been dismissed. That's still alive in the federal court of Utah. So we have that, and we also have a motion for reconsideration. Let's say they vote to not let it move forward. Well, with this groundswell of letters that you're creating, one that you launched, which is fantastic, and with a motion for reconsideration, that could change things as well. So we have backup plans here. It's not we give up if this thing doesn't move forward, but I just don't see any possible way. It can't move forward, but God is in control and he has his plan. And that's what we feel like. We're just taking part in this incredible production and we're players in it. And a lot of people are like you guys are players in this. And we're going to go through the doors as they open up and just enjoy and be excited and praise God for the outcome.
Well, the one thing, Loy, that I think people need to remember, Loy and Nino, this case ultimately is about oaths. We sing songs about our America. We say an oath to the flag, our Pledge of Allegiance. We say oaths, and the question is, be like a marriage oath. Does it mean anything in America anymore if you pledge an oath of marriage? Is it meaningless? Well, courts hold you to, certain responsibilities in a marriage contract. So obviously it does have some meaning. People cheat all the time on it, but when you're actually held feet to the fire, you've made a contract with somebody that has to be honored. That's why you have divorces and separation of all the stuff, because you made an oath. If you didn't want to make the oath, it wouldn't be the same thing. That's why just being together isn't the same as actually going through the process of saying an oath and of marriage and doing a contract, a marriage contract like that. So if it doesn't mean anything, why would we require police officers, military personnel, and elected representatives and senators to say an oath of office, what they will and will not do when they come into office? And this is a violation of their oath. They took an oath to protect the Constitution, which is a contract between the American people and its government, against all enemies, foreign and domestic. When 100 members of Congress, and now 50,000 people in letters have said, hey, we want to hold these people to their oath. Congress just flew right past it. We're not going to pay attention to the oath. We're not going to investigate anything because it suited their purposes. They wanted a particular outcome, and they just ignored the call that a bank robbery was taking place. And we want to hold them to those oaths. They should have done an investigation, and whatever the outcome, that's the outcome. But they needed to do an investigation to protect the Constitution. They didn't do it. That makes them not suitable for public office. They won't honor their oath. That's a violation of their oath not to do an investigation. I don't care what the outcome was going to be or what they were afraid it might be. They had a requirement. It was a legal requirement to honor their oath, and they broke their oath by not allowing that an investigation happen. They could have done an hour investigation and said, well, we did it, and we didn't find anything. They did zero. And therefore, they're not suitable for public office. They need to be removed, and they're out. That's what.
So the consequences, the consequences of this will be the removal of 380 plus congressmen, and even could Biden could all of them just come down with this? And could this lead to other criminal?
Oh, absolutely. Then there's a referral request in the petition for the Department of Justice to investigate for criminal actions, and also there's a John Doe's 1 through 100. So the Supreme Court has the power to add defendants to the list. Now, the Supreme Court justices have taken two constitutional oaths. One is the judicial oath, which includes upholding and defending the Constitution, and also another constitutional oath that's probably identical to the congressional oath or the military oath. So they've taken two oaths to the Constitution. Now, Elizabeth Freeloader, the U.S. Solicitor General, has also taken an oath to the Constitution. So this is shedding a tremendous amount of light on the importance of oath taking and the need for it to be binding. In other words, it's not even an oath. So I personally think that Elizabeth Freeloader, in her mind, knew she had to sign a waiver, and she did it in good faith and conscience. It wasn't because she just thought it was, not necessary. She could have just waited and let it expire. But that was a statement she made, filing a waiver to oppose it before it goes into conference. And so they may be talking I mean, the Solicitor General could concede and say, "Hey, I support the petitioner in this," and then the justices would have that much more merit or reasoning to move forward. And I think the biggest thing here might be the execution of it all. But I think I've had my own plan where the U.S. Marshal Service served my summons and complaint. Why could they take, for the court order, take a list to the sergeant at arms and say the following members of Congress and the executive branch as well that their credentials be canceled and have that done. And then there's special ops teams from the government that could go into the broadcast stations so that everyone doesn't go crazy, and when they hear the news of what's happening, so that see that this is a very positive thing, and that those vacancies are going to be filled by anyone that wants to run. I mean, there are many people that have run against all these people in office before, so it opened up a tremendous number of campaigns. So that would be a positive support of the petition. And with the news broadcasting in real time the truth, I mean, this would be, there wouldn't be the promotion of riots and destruction of life and property and crimes like has happened because of some of these representatives and because the news was actually inciting all this destruction. So I think it can actually be a positive, and smooth transition.
So as we approach January 6th, as this keeps drawing closer and closer, both of you are very optimistic on what's approaching.
Absolutely. I think, but then God is in control, and
Right.
if He doesn't do our plan, He's got a bigger one in mind.
Right.
So we just have to keep the faith and see what happens. And this is raising a tremendous amount of awareness to the people that they haven't had a binding oath, and they've been violating the Constitution by creating legislation, federal and state. In California, there's a state law having to do with perjury, and the words actually exclude politicians in the oath of office from them being liable to perjury charges. So in other words, you can lie your guts out when you're taking an oath. So that would be just wiped away. And then think of the people that would not want to run for office if there's a binding oath. They wouldn't want to run. And there are people that are willing to lay down their lives for this country. They do it in the military all the time. And those are the kinds of people that would not be afraid of a binding oath. And those kinds of campaigns would take over the campaigns that have been for the purpose of exploiting the position of being a representative or government official.
Juanito, do you want to lead us out in prayer? I got to jump on with Daniel Brinkley right now.
Father God, we thank you for watching, for bringing people forward, for raising up in people's hearts and minds to see justice done. I thank you for the Brunson brothers and for putting this in their ability and their hearts to proceed in this way. I thank you that there are people in the Supreme Court, justices, who have sought this out as an option. And now we pray for clarity of mind, clarity of purpose, and protection for all of those involved as we proceed forward. And we ask you that there be perfect peace in the hearts of those moving forward to do the right thing, and protection. And then as smoothly and with as little disruption as possible for the least damage to the innocent and to those who would be affected by this decision, and for the best outcome for America. We thank you that you ask us to honor our oaths, and that is a requirement. We know there's courts of heaven and courts on earth, and there's things that may be gotten away with here on earth that get resolved only in your heavenly court. We ask that you resolve this matter in your heavenly court. Protect America for your purposes and what you've had in mind for America all from the beginning, all the way back to the Pilgrims and before. We ask it in Jesus' name, by the blood of Christ. Thank you, Father.
Amen.
All right, guys. I appreciate you both coming on. I'll put this up soon. So, Juanito, I'll keep in touch with you. And Lloyd, could I get you on while we approach January 6th or shortly thereof or after?
Sure. Yeah, just reach out like you have in the past.
You got it, Lloyd. All right, Juanito. Thank you guys for coming on.
Yeah, but by the way, remember, same prayer for the Matador. They're trying to get him. It's the charge, man. They're coming.
All right, guys.
It's going to be amazing. Something's going to happen here. It's going to be amazing, bro.
This could be a part of that. Yep. Thank you.
It is.
All right,
Thank
guys.
you, Nino. Thank you, Juan. I'll see you.
All right. Talk to you a little later, Lloyd. Bye.
Be inspired, my friends.